All right, law nerds, this is Professor Tracy back with another defense in our coverage of defenses to formation. Let's get right to this so we can get it over quickly, shall we? So we're first going to look at a quick overview of the rules when we're talking about what does it mean that illegality or public policy can serve as a defense. So our general rule is this, that, and you can read it, but I'll read it for you just in case you can't be bothered to read the screen. So it says that a contract or a provision of a contract may be void or voidable if the subject matter or consideration of the contract is either illegal or against established public policy at the time of formation. We're going to translate that so it makes more sense to us, but in short, we are looking at the substance of the contract, the terms of the agreement, just as we were doing with unconscionability, but instead of looking at whether those terms are one-sided or unfair, what we're looking at is whether or not the terms of that agreement are directly illegal, meaning that they violate an established law, or they go against public policy. So although they may not be in contravention of a particular law, they nonetheless run contrary to public policies that are reflected in those laws or in statutes and or cases that have been decided by the courts. So and this is key to understand this second point, that we are evaluating this illegality or violation of public policy at the time of formation. Right now, that is what we are talking about. If there is a contract that is fine when it is formed, that there are no laws being violated or public policy being run afoul of, but subsequently Congress passes a law or the state legislature passes a law after the formation of the agreement, and now it's illegal, that we will deal with later when we look at our changed circumstances defenses like impracticability, impossibility, and frustration of purpose. So we can save that exciting topic for later. We are looking then at sort of three categories of what we might think of as three categories of violations of the law or of public policy. The most obvious problem here is if the contract in question involves the commission of a serious crime or tort. That one we'll give an example in a minute, but that's clearly the one we can all go, yes, of course, that should not be enforceable. But we have this on the opposite extreme, we have a violation of a trivial public policy or law. And we'll talk about what that means in a second, but that's on the opposite end of the spectrum from the commission of a serious crime or tort. And then we have this middle ground, which I am calling doubtful cases, where it appears like this contract possibly shouldn't be enforced because it involves some sort of violation of the law in its performance, or it appears to run afoul some sort of public policy that's embodied in the law. But it's not clear cut. So those are the complicated cases, which we're going to spend our time on mostly, are those doubtful cases. But let's first look at what we mean by these things, the commission of a serious crime or tort. It's simply put, if you have a contract, for instance, that is, well, one of two things, right? It could be that the contract itself is made illegal under the law, like a contract to have somebody murdered would be a conspiracy to murder, or a solicitation of somebody hiring somebody to murder somebody else. Those kinds of situations, we could say, yes, that is clearly illegal. It involves the commission of a serious crime or tort. Same with the sale of illegal drugs. There are federal and state laws that make such contracts illegal, clearly illegal, and therefore they are plainly void from the beginning. They are not voidable, they are unenforceable. So if we look at an example where where in some weird alternate universe, Bob is dealing pills. This is what occurs. So Bob says, "Hey, Bo, want some pills for $50?
That'd be great. I've been feeling terrible. Maybe they would help."
So they have a contract, right? This is a simple purchase and sale of goods, right? This is exactly the kind of contract we like, right? Straightforward, sale of goods for $50. It can be oral. We're fine. This seems like a fun time. So we have this contract. Then Bo is paying the $50, and then Bob breaches, right? Bob breaches.
Bo's like, "Now where are my pills?"
"Thanks for the $50. I'll get you the pills eventually. Maybe, possibly, if you're lucky. See you later, sucker." So Bob breaches. He takes the $50 and runs. He never delivers the pills. And then Bo wants to run into court to enforce this contract for the sale of illegal drugs. Of course, he's not going to be able to do that because it was void from the beginning. It's an illegal contract. So this is the clearest, easiest example of no, of course he can't run into court and enforce that. It's void from the get-go. So what about on the opposite end of the spectrum, this violation of a trivial public policy or law? Here, we're saying that the contract itself, there's no law in the books that says this kind of agreement is illegal or problematic, but nonetheless, that in the carrying out of that contract, in the performance of it, it involves some sort of minor violation of the law. Typically, such contracts would not be void. They would be enforceable. So for instance, we can see this, and you have Bo going,
"I'm selling an awful lot of my furniture. My new place is a lot smaller. Are you interested in one of my couches or beds? Maybe my kitchen table?"
"I would be, but I have no way to pick up anything and get it to my house."
"Oh, that's not a problem. I'm renting a truck for a few days when I move. I can deliver any of the furniture you're interested in."
"Okay, in that case, I'll buy that couch from your den and the guest room bed. Can you deliver them on Thursday at 5 p.m.? So Bob promising, "I'll pay for the furniture and your delivery of that furniture," and Bo's going,
"Works for me. I'll deliver the couch and bed on Thursday at 5 p.m.
So he's promised, I'll deliver that for the furniture he wants, the bed, the couch, to his place Thursday, 5 p.m. So we've got a contract, and now Bo shows up. The key thing here, though, is Bob's living in a townhouse, and out front is this sign that says no parking between 4 p.m. and 7 p.m. And you've seen these signs, and often if you live in an area where during, say, evening rush hour, which would be between like 4 and 7, there's more traffic, so they don't want people parking on the side of the road, on a particular side of the road at that time. That's what we have going on here. And yet, Bo shows up with his truck and delivers the furniture in violation of that sign, right? Parks there in violation. And now Bob says, "I know I owe you for the furniture and the delivery, but I'll catch you later when I can come up with the money." So he's, you all have friends like this, right? The people who are like, "Oh, I'm good for it. Trust me, I'll pay you back sometime." So here, that's Bob, right? And Bob's not paying. So Bob breaches. And in this situation, then, here's the question. If Bo sues, now what's Bob going to do? He's going to say, "Oh, it was illegal because in order to carry out the agreement, you had to park somewhere at a day and time you shouldn't have. It was illegal for you to park there. So the performance of the agreement called for you to do something that was illegal, and therefore the whole agreement should be void." And the answer is no. That is not the kind of thing that we're worried about. right? That we're not going to void the agreement. And we could weigh out our factors here, but we don't need to, because this is such a trivial thing that we don't need to go, well, let's look at the policies in favor of enforcement and those, and those against it to see how everything sort of stacks up. And we don't need to do that. We can look and go, this is trivial, clearly. This should not be the kind of thing that Bob can just not pay Bo at all because of this, oh, you parked on the wrong side of the road at the wrong time in delivering the furniture. No, as Bo says, time to pay up, Bobby. So let's look at this third category of doubtful cases, which I said is where we're going to spend our time. This is where it's not falling into either of the extremes where it's like, well, there's clearly a law in the books that this directly violates, like selling illegal drugs, or this is so trivial, are you kidding me? Do we really need to go to all this trouble to balance everything out on the other side, like a parking violation? Instead, this is somewhere in the middle, and there we have to balance things out and weigh the factors for and against enforcement of the particular contract. So, if we're looking at a balancing test, what are we balancing? The importance of enforcement on the one hand versus the importance of whatever public policy is at issue. It could be one that is embodied in a statute or an ordinance reflected in the law somewhere, or simply a policy that's reflected in the common law and court precedent. So whatever policy is at issue, we're weighing the importance of that policy versus the importance of enforcing it. And so let's unpack that. When we say importance of enforcement, what we mean are, what are those things that favor enforcing the contract? We are obviously, one of the biggest would be a general policy in favor of freedom of contract. We want people to be able to make contracts. We want to enforce those. The more times we say that a contract is not enforceable for some reason, we are cutting back freedom to contract, because we're saying, well, you can contract for any kind of thing you want except this, except that other thing. And you've got a contract here whether you want to or not. Though every time we do that, we're impinging on freedom of contract, and often that's for good reason. But nonetheless, that is a policy that comes into play here, and we've got to consider, is it worth impinging on freedom to contract here? Also, we're looking at what are the expectations of the parties. They're expecting, presumably, that this contract would be enforced. So we're looking at their justified expectations, meaning if they don't really have a good expectation, a reasonable expectation that the contract would be enforceable, then that's not worth really considering, right? It's got to be a justified expectation. So for instance, if we were analyzing a contract that was a contract to hire somebody to kill somebody else, neither of those parties have a justified expectation that that agreement would be enforceable if they ran into court, right? Like if you paid $10,000 to somebody and they didn't murder the person that they were supposed to, you cannot go into court and be like, hey, judge, I paid this person $10,000 and they didn't kill my mother-in-law like they were supposed to. So I should either get my $10,000 back and we can just be square and I'll find someone else to do the job, or he should be forced to do that, all right? Forced to carry that out. Order him to do that. So that obviously wouldn't be a justified expectation. The other thing, and I think closely related to this expectations and wanting to ensure that those expectations are met when they are justified, is this predictability of business relationships, that in order for the whole world of commerce to work, things need to be predictable. Part of the value of a contract is that it makes things predictable. And if people do not do what they promise, then the party knows they can run into court to enforce that agreement to get a remedy. So that creates incentives for people to do what they promise to do, and that creates predictability. And giving a quote-unquote out through a defense of illegality in public policy obviously runs counter to predictability. And the suffering of a significant forfeiture, any time we have a situation where somebody has performed or done work and then not received the benefit they expected under the agreement, that means they would suffer a forfeiture. And as we will see, when the defense of public policy and illegality applies, if the contract is rescinded, restitution is typically not available. So if one party, for instance, already paid a bunch of money or already performed, then there's no restitution available for them typically, and there could be a large forfeiture, meaning they relied on this agreement and performed, and now they're going to get zero of the fruit or the benefit from the contract they expected to receive. Then, but on the other side, right, we said these are the things, the importance of enforcement are these arguments in favor of enforcing the agreement, but there are these arguments that are against, right, because we're weighing it against some sort of public policy that is saying, well, this might be more important than this contract and the enforcement of it and the policies in favor of enforcement. So we have to look at if we have a statute that's at issue that is being impinged on, we have to look at what is the importance of that public policy that's embodied here, and what are we going to be furthering that policy when we void the contract? Will it actually be helpful to do that? Or are we just voiding this and not really accomplishing anything that actually furthers the policy? Because sometimes it doesn't. And we'll see an example here in just a second. And we're going to look at what is the seriousness of the misconduct that's at issue. As we've seen, sometimes if you're parking somewhere where you shouldn't have parked for 15 minutes as you unload two pieces of furniture, not that serious, right? Which is why we didn't need to analyze it, because it's very clearly one-sided. But in any situation, you would want to look and say, how serious is this misconduct that we're looking at? Obviously, on the complete opposite end from the parking violation is the selling of illegal drugs, or even more serious, the murdering of somebody. So remember, we said it's a balancing test, so we're weighing these things against one another. And so if the importance of enforcement outweighs the importance of whatever public policy it is at issue, then we're going to enforce the agreement. And if the opposite occurs, that we decide that the public policy is more important than the importance of enforcing the agreement, we will not enforce the agreement. Instead, we will void it. So let's talk about an example, and this is more serious, and I thought this was a helpful example, which is why I used it. It's not a fun Bob and Bo example, but it does drive home how this works. So here, what I want to look at is the situations that have arisen where you have an undocumented immigrant who's suing to collect unpaid wages under an employment contract. So think this is someone who's entered the country illegally as an undocumented immigrant. They've been working for an employer, and the employer is withholding wages, and they're suing to say you owe me under an employment agreement for these unpaid wages. And so we can look and say, okay, there are federal laws, federal immigration laws that say what? That prohibit undocumented immigrants to enter into an employment agreement except in prescribed circumstances. So we can say, okay, it's generally the actual agreement itself is the undocumented immigrants are generally prohibited from this. However, it's important to understand this. The federal law does not specifically make the agreements legally unenforceable. It doesn't say they're void. It doesn't say that they are voidable. It just says that you're prohibited from entering into these employment agreements. And typically, if there are sanctions or enforcement mechanisms, they're typically aimed at the employer, not the undocumented immigrant. So the question comes up here, though. We have a federal law that does not directly tell us that the contract was illegal between the undocumented immigrant and the employer. It doesn't say that was void, right? That was void. So we can look at this, and courts have, and said, what's the importance of the public policy that's embodied here? Like, why do we even have these laws? These laws, well, obviously, they're intended to, one, discourage illegal immigration. That we don't want to incentivize people to say, oh, you can come here and get a job even if you are illegally immigrating into the country. That's the idea, right? That it discourages that. But also the idea that people will put forth is that it, quote, safeguards American labor from unwanted competition, right? The cheap labor argument that illegal immigrants will come in and take all the jobs and take away, jobs from lawful Americans. That's the idea. That the one of the policies behind it. And undoubtedly, those are the two biggest policies embodied in that law. And note this, though, is as we're thinking about one of the things we said when we're talking about the importance of public policy is whether voiding this contract here, this employment agreement between the employer and the undocumented immigrant, and saying, yep, we're going to void it. They have no obligation to pay these unpaid wages. They have a defense, right? So that's what's going on. Remember, the employees are raising this as a defense. But here, it's important to understand that voiding this agreement will not further that policy. And you might say, why? But sit tight for a second, because you'll see when we look at the policies in favor of enforcement. So when we talk about importance of enforcement, we need to say what? Okay, what's going to happen? The undocumented immigrants will suffer a forfeiture. They have done work for which they will not get paid. It's also contrary to the idea of predictability and freedom to contract, right? That enforcing this ensures that, consistent with a principle that is well established since time immemorial, right? That one who does work for someone else can expect to be paid, right? We can think we can go so far as to say it's even biblical, right? Don't muzzle the ox as it's treading out the grain. That in other words, if you're doing the work, you should be paid for the work. That's a very well-established sort of idea. And this would further that, paying that. But related to this last thing, that voiding it, we said under the importance of policy, we said voiding the agreement would not further that policy. And here is why. Because it would allow employers to employ undocumented immigrants, to knowingly employ undocumented immigrants, and then purposely and with impunity, if we say, yeah, we're going to void this agreement, it would be with impunity not pay them. And so you would say, well, isn't that going to further our policy by voiding agreements like this? No, it incentivizes doing it, right? Because then they would say, well, of course I'm going to employ him because I know I don't have to pay him. So they're going to employ more. You're creating the wrong incentive. So the answer is no. In that the courts have said that enforcing these or avoiding these agreements would not further the public policy embodied in the agreements, because it would actually change the incentives such that these employers would want to hire these workers, and then because they know they cannot pay them and not have to worry about it. So it's free labor. So as you might be aware, we have a history in this country of that being a problem. So here, when we talk about this, well, what are the remedies that occur in a situation like this? What occurs if we were to void an agreement? What happens? Well, just like when we're talking about unconscionability, because we're looking here at the substance of the agreement, and what it's about, what its subject matter is, what its terms are. Yes, of course there can be rescission. You can sue. The agreement could be void and rescinded. Sometimes it's not that the entire agreement is illegal. So it depends what we're looking at, how complex it is. Obviously, if it's a straightforward agreement, which is just about the sale of illegal drugs or a contract to kill somebody, then that's, there's no sort of severing out the offending provisions. But if you have a more elaborate contract and you have particular provisions that may be problematic, we can sever those out from the agreement, assuming they are not so central to the agreement that the thing would fall apart, right? As long as they're ancillary to the rest of the agreement, it's fine. We can sever them out and the rest of the agreement can be enforceable. And similarly, we could have reformation, which is rewriting or replacing those provisions of the agreement that are problematic, that run afoul of public policy. And we typically see that number 2 and number 3 in some of these other, and I mentioned this earlier, sorry, I was starting to talk about something else, and we'll get there in a second. But here, restitution, again, generally not available. The idea historically being that we're not going to reward anyone from this, so things are just going to fall where they fall, so you enter into this illegal agreement at your own hazard. However, there are, when I say exceptions here, there are exceptions to when we do allow restitution or may allow restitution, which is if there's going to be a disproportionate forfeiture, meaning that one party is going to forfeit a substantially larger part of the fruit of the agreement than the other, that would be a reason to allow restitution. Also, if perhaps one party knew what they were doing was illegal, but the other did not, that if there was excusable ignorance. So, and what that is getting at, right? And you'll see this with some of these other exceptions, but excusable ignorance is getting sort of at the culpability. If one party is not as culpable as the other party, then we may allow some sort of restitution, maybe for that person's benefit, because they're not as blameworthy. And so that's similar to with this other thing, right, where we talk about not being equally wrong, same kind of thing. And then withdrawal, if this is, if you've had criminal law, people can withdraw from a criminal conspiracy. That's literally what we're talking about, is if somebody may withdraw from this before it gets too far down the road and gets performed, then again, they may not be as culpable. And so we might allow restitution. But I want to just briefly say a couple things about 2 specific kinds of contracts here. And one is non-compete agreements. And this is something I think worth exploring more. I'm not going to go into excruciating detail about this, but these typically arise in one of 2 contexts. Not always. There are other contexts that can come up, but the most common are either in an employer-employee relationship where it's said when you leave, right, if you are terminated or when you leave our employment, then here are the restrictions that are placed on you for this period of time. Typically, it is a restriction as to what activities that former employee may engage in, and within a certain geographic region relative to the employer, or former employer, I should say. And then also it would have a duration of years. And so that's one context. The other would be, let me say this, with an employer-employee situation, typically what's being protected there are any sort of trade secrets, confidential things that concern about those being used, even if it's sort of certain methods or that are proprietary to that particular employer, trying to protect those. And relatedly, a customer list would be the other thing, that if you are, for instance, a doctor or what have you, then your patient or customer list is one of the things you would want to protect. And those are typically what these are protecting. And to be honest, those are the only kinds of things that courts typically find as to be of sufficient importance to justify a non-compete agreement. Beyond that, it's going to be difficult for an employer to justify it. I'm sure there are cases out there, but those are the 2 you're going to see. The other context you'll see this come up in, though, is in the purchase and sale of a business, that if a buyer is buying a business, then it is not uncommon to impose a non-compete on the seller who just sold you the business in order to preserve the quote goodwill that accompanies the business that was just bought. Because if that seller were to turn around, open up a similar business down the road, then that would take away greatly from the value of the business that was just bought, and we call that the goodwill. So those are the two contexts. And there are, as I mentioned, sort of three typical restrictions here. One is the scope of activity, meaning what is it that we are prohibiting the former employee from doing or the seller of the business from doing? What activities are they prohibited from doing? And we want to make sure that the restriction is reasonable, that we're not prohibiting them from doing things which in reality don't affect our interest, would not harm us. So geography, meaning how wide of a scope is it? Is it within 10 miles of the business they just sold you or the employer you just left, or 20 or 50, the entire state? What is it? Where are the restrictions imposed? Geographic, and then time. What's the duration? Is it for a week, a year, 6 years? How long is it? And when we're looking at this, we have a strong public policy that is in favor of against, I should say, restraints on trade, right? So in favor of free trade. And so the view is that non-competes impose on that, right? That they are a restraint on trade. And so we only will allow these kinds of restraints if they are reasonable. And so when we say reasonable, we're going to look at if it's an employer that we're looking at an employer-employee situation with a non-compete agreement. We're going to ask, what are the legitimate interests of the employer? Is it really about a customer list or a trade secret or some sort of confidential process or information they have, some proprietary thing they're trying to prevent this former employee from profiting from? What are they doing? Right? What interest do they actually have? And the kinds of things that have been considered legitimate are pretty narrow, like the kinds of things I've mentioned. Then we're going to look, though, also at what is the hardship to the employee. And here's something we can say: to the extent that the interest of the employer has stopped, then it's all hardship, right? If, for instance, after, say it's a situation with a doctor, and that the data from the practice that was left shows that generally after about a year, people make their decision about whether they're going to stay with the practice or not, or they have a follow-up appointment or what have you, that typically patients are returning at that point, and that if they're going to be returning and continuing on, it would all occur within a year. Then anything over and above a year is just pure hardship. They may have a legitimate interest in protecting their patient base, their customer list for a year, because that's about the time needed for them to know, are these patients who used to see this doctor who just left are going to come back, stick with their practice, or are they leaving? They would know within a year. So there they have a year, but anything above that would just be pure hardship, because you're just restricting to restrict, and there's no good justification for it. So those are the kinds of things you're looking at. And also, when we look at these things, we're looking at each of the three categories in terms of what's the scope of activity. Is this like the only thing the employee knows how to do? And you're saying, well, you're not going to be able to make a living anymore because of the way we drafted this thing, but maybe 5 years from now you can. Then obviously that's a great hardship. And then one of the things here too is the injury to the public. And the size of these circles literally has nothing to do with their relative importance. It's purely aesthetic. Isn't it very nice looking? But it is. So here, when we talk about the injury to the public, what we're saying here is if this person cannot open another business, if they just sold a business, or if they cannot continue to practice their, whatever medicine they practice, or if they're an accountant or a lawyer, if they can't do what they're doing, what is the loss to the public, right? The loss of their services and labor, or the loss of their revenue in terms of having a place of business to employ people, etc. Those kinds of things. What's the injury to the public? That's what we're concerned about. Then lastly here, I said there are two specific categories of things I wanted to look at. The other thing here would be contracts violating licensing laws. And what we mean here is that typically the way these arise is somebody hires somebody to do, say, plumbing work, or could be to be their lawyer, or to be their accountant, or do some sort of financial advising for them or whatever. And that other person is not licensed, and the customer says, I'm not going to pay because you're not licensed. This was illegal. The contract is void. Under state law, you had to be licensed. Now, let's be honest. If they're lawyers, yeah, no way, unlicensed practice of law. If there's one thing we lawyers are good at, it's penalizing people who aren't lawyers from practicing law, right? Protecting our own profession and our own customer base and our sources of revenue. And certainly no court's going to be sort of loosey-goosey with the enforcement of that. But in other contexts, which don't involve our own self-interest, we might be a little more generous and sometimes allow those contracts to be enforceable. So that's what we're talking about here. We can sort of generalize here and say this, which is we need to look at why is there a license requirement? And to be honest, sometimes it's about regulating the industry, meaning that we really have concerns about safety, about health, about people's well-being. So with the law, for instance, we want people to competently represent people because either their livelihoods are at stake, or their lives may be at stake, or their freedom may be at stake. There are big things at stake. So it makes sense that we would want people to be competent and if they're going to be providing legal services. But understand, we license all kinds of things. For instance, hairstylists and barbers and plumbers and things. And often, though, those things too are regulated not for purely like, oh, we just want people to pay us money so we can make money to get this piece, so they can get their piece of paper. And often there are health and safety concerns. Like if you think about a plumber. A plumber is working with water and sewage, right? There are great health and safety risks involved. We need to ensure that they're not creating problems that are going to endanger people's health and lives. And so we regulate it for that reason and require them to be licensed. The same is true with hairstylists, barbers. You are cutting somebody's hair. You are using sharp instruments. There's that part of it. Part of it, though, is you're working on people and with people, and there's those concerns, and you're working with things that need to be disposed of properly, like human hair and those kinds of things that. There's all kinds of things, health and safety concerns that arise in a lot of professions, and that is often why they are regulated. And if that's true, then that's going to mean that, and by the check there, what I mean is it's likely that we would say, okay, yeah, that's a valid reason and we're not going to enforce this agreement when somebody unlicensed has provided this, because we don't want to incentivize people to not get a license. So in that case, we'd say, yes, this is the situation where you need a license and it's important to uphold the law. However, you will find courts say that if it's just about generating revenue, that this is just about making money, and there's really not any legitimate health and safety reason or other reason behind it, then courts are going to be like, yeah, whatever, it's true, they don't have that, but nonetheless, so we're going to enforce the agreement, and then you would typically say, and, go get the license you're supposed to get. So that would mean, meaning I probably should have given these the opposite marks as I sit here and think about it. But nonetheless, in this case, the agreement would actually be upheld likely be upheld, and this is meant, the X was meant to say that's not a good reason for voiding it, that the defense is not going to be upheld, is not going to work, is what I was trying to say, and in the first instance, it likely would be. So that's it. So I hope that's helpful, and I'm sorry it took me longer than I hoped it would to get through all that, but as always, if you did find it helpful, please like and subscribe, and I will see you again soon in another video. Thanks again. Bye.